I'll try to be as brief as possible and pointed. Well, as my first submission is just touched upon briefly by my learned friend, but I want to cite a judgment on that. And that is this, Wallace. You have a power given to the Election Commission. Let me tell you the structure of the argument of this first point. This is the first point, Wallace. You have a superintendent's direction, etc. power in 324. We all know the Election Commission has that power. And then you have a power given in 327 to Parliament. It's a little important constitution. Parliament to make laws. So just see the language, just see the Constitution, 324 and 327. Kindly give the Constitution. So you just be ready with the case law. I'm using that for them, copies for them. Yes. So I'm not going to read it, but just see the structure. My lord is familiar. Superintendent, direction and control of elections. Now suppose it was untrammeled by a parliamentary law under 327. So it's totally unoccupied field. Your lordship would have nitty-gritty created by all kinds of enumeration forms, etc. I hope I'm clear with this. Now 327, see the first line now? Subject to provisions of this constitution, Parliament may from time to time by law make provisions with respect to all matters relating to or in connection with. Now Parliament goes ahead and does make such law, the so-called ROPA, R-O-P-A. When it makes such law, it says that the only forms you can use are 4, 6, 7. I'll go to the nitty-gritty in a minute. Not your own new form, which is not supported or sanctioned by parliamentary law. That's my first point. And you cannot allow your supposed, according to me, non-existent executive power to operate in the interstices where parliamentary law exists. So it's an important problem because the whole thing here, it is common ground that some of the forms and the queries they are asking is not in the Act. Your Lordship has 3 crucial anchor forms in the Act, 4, 6 and 7. What we are asked now is admittedly divorce that. Now the attempt is to trace the power to my plenary power under 324. Now remember, you have occupied the field by parliamentary law. Now 2 arguments can come. Parliamentary law does not prohibit me, that is Election Commission, from doing X, Y, Z. Or a misreading of the first opening 3 words, subject to the provision of this constitution, means subject to 324 also. Both have happily been debunked by my lords in an important judgment. Once Parliament occupies and you have to follow, otherwise you are rendering nugatory. Parliament decides, chooses to have only 4, 6 and 7. It chooses not to have 4A, 6A and 7. Now you can't say that because Parliament does not have 4A, 6A and 7A, therefore I will act in the interstices on my executive power. That's the judgment. Please turn to that. Give the judgment. Page 42 of the written submission. I also have a written submission. Give it. But I have given my written submissions. I will hardly use 5 pages of this. It's a very bulky one. Forget it, Maras. Don't go into it. But next to that, Maras, is also this judgment. Yeah, I think. This judgment is, Maras, Chose versus Pillai, 1984 to SCC 656. Because this is a fundamental importance principle because the whole case is about the EC purporting to act divorce specific statutory power. We have no problem if you act on 4 and 6 and 7. Now I am attacking the root of the non-existence of any other power altogether. We are now not on individual grievances and all this, but this is also serious, but we are on the legal principles. So come to this judgment, it's a 3-learned judge bench. In 84 to SCC 656, which is page what? 42. Page 42 of my written submissions. We have annexed it. Come to the relevant paras, keep it flat. Keep it flat. Well, let's come to... No. 7. I'm interested in later paragraph to start from 7. The real paras are 23 and 24, but just start with 7 just so that your lordship gets the context. May I read 7, Manas? 22 and 23. Give me 2, but don't keep jumping. Give me 22, which one? Just. Don't keep saying kabhi 22, 23, 24. Just give me 2 paras. Does my lord have Manas para 7?
Yes, yes.
Another golden rule laid down by this court on the interpretation of statutes is that we should so interpret the language of a statute as to suppress the mischief and advance the object. It is true that 324 does authorize the Commission to exercise powers of superintendence, direction and control of preparation of electoral rolls and the conduct of elections to Parliament and state legislatures. But then the article has to be read harmoniously with the articles that follow and the powers that are, mark the word, with the articles that follow. That is 327, Malas. It follows 324. And the powers that are given to the legislature under entry 72 of list, union list, and entry 37 of state list. The Commission, in the garb of passing orders for regulating the conduct of elections, cannot take upon itself the purely legislative activity which has been reserved under the scheme of the Constitution only to Parliament and the state legislatures. By no standards can it be said that the Commission is a third chamber in the legislative process within the scheme of the Constitution. Merely being a creature of the Constitution will not give it plenary and absolute power to legislate as it likes without reference to the law enacted by the legislatures. Now come to 22. And Manas, I repeat, they are actually in the guise of this doing substantive changes, which is legislation. They may camouflage it. Oh, it's nothing, it's just a procedural rule. All these 75 years or all these 22 years, we have not had the requirement that you fill up a form first and then I will presumptively retain you on the list or remove you. This is substantive change, which can only be done by a legislature. 22. Para 22. Further, such an absolute and uncanalized power given to the Commission without providing any guidelines would itself destroy the basic structure of the rule of law. It is manifest that such a disastrous consequence could never have been contemplated by the constitution makers, for such an interpretation as suggested by the counsel for the respondent would be far from attaining the goal of purity and sanctity of the electoral process. Hence, we must construe 324 to 329 as an integral part of the same scheme, collaborating rather than colliding with one another. A perusal of 324 to 329 would reveal that legislative powers in respect of matters related to Parliament or the state legislature vest in Parliament and in no other body. The Commission would come into the picture only if no provision has been made by Parliament in regard to the elections to the Parliament or state legislatures. Furthermore, the power under 324 relating to superintendence, direction and control actually vesting on merely all the executive powers and not the legislative powers. In other words, the legislative power of Parliament or of the legislature of a state being made subject to 324. So this answers the query that somebody argues that subject to means subject to also 324. No. Subject to only means that no law made by Parliament under 327 or by state legislature can take away or deprive the Commission of the executive power in regard to matters entrusted to it, superintendence, direction and control. The right to file election petition, forget that. Come to 25. The summary is very good, Malas. The summary is very good. It puts it a focus. To sum up, when there is no parliamentary legislation or rule made under the said legislation, the Commission is free to pass any orders in respect to the conduct of elections. Where there is an act and express rules made thereunder, the Lordship will mark ROPA and the rules thereunder. It is not open to the Commission to override the act or the rules and pass orders in direct disobedience to the mandate contained in the act or the rules. In other words, the powers of the Commission are meant to supplement rather than supplant the law, both statute and rules, in the matter of superintendence. Where the act or the rules are silent, the Commission has no doubt plenary powers. And then Malas particular direction. Now Malas developing this a little more, it is common ground that we have 4, 6 and 7. What is 4, Malas? Form 4. Statutory form prescribed, which is a form for a de novo rule or a de novo Malas change in the role, which is form 4. And form 6 is for inclusion. And 7 is if somebody outsider objects and I challenge him and I fight it out and I retain myself. Now, so we are not concerned. I'm not challenging the validity of these rules. That's not this kind of a matrix. I asked myself a question. In June 2025, the form which was issued, simple question, where is it found in the rules made by the ROPA? In June 2025, you had a form. Forget that your lordship gave safeguards. I'm arguing legal points for this. That form says 11, 12 or whatever documents. Does such a form exist anywhere? Clearly it does not. That form could be prescribed only by and only by delegated legislation under the Act through parliamentary law in the form of rules. 324 does not plug that gap. So that's the first point. The second point is related, of course, all that you by that form made a rule also that unless and including inter alia for a certain date proving both your parents' certificates, for a later date only one parent, and for other date only yourself. The second question I am asking myself, where does any parliamentary law or rule permit that? You are asking for a birth certificate cumulatively of two parents, one parent or yourself. And you have said that it is basically for verification of what? It is not for verification of a photograph. It is not for verification of the fact that I am standing in front of you. That's a different verification. I have no problem with that verification. If I am a dead man and he tries to become an imposter for me, that's a different verification. This is a verification for deciding whether I am a citizen or not. This is the second aspect. The third aspect, of course, is that the scheme of the Act and the rules envisaged an individuated exercise, not a blanket en masse exercise. This is the real problem. Nobody denies to the Election Commission an individuated case power. If I bring material to show that my learned friend here is clearly not a citizen of India, nobody is saying it will be brushed under the carpet. But that's a bilateral or a trilateral individuated exercise. This is a very important conceptual issue. Never before in the history of India, and not under the ROPA, not under the rules, are you allowed a en masse right at one state alone for crores. And next state and next state and next state will be crores plus crores plus crores. Where is the power? So there is a slight nuance here. Your lordship is being told by the other side to create a bugbear of a fear that, look, if you don't have the power, how will you decide citizenship? But then what is Rule 7 for, and what is Lal Baba Hussain for? Let us look at those two things. Look at Rule 7. The Act, to the extent it wanted to, took care of it. Now you want to expand the Act, that's not your business. Come to Rule 7. Sorry, rules. No, Form 7. Form 7, I'm sorry. Where is it? Where is it? Form 7. So, I'm sorry, I said Rule 6. It's Form 6. Form 7. Form 7. Voter application form for objection for proposed inclusion, deletion of name in existing. So, an individual verification to assuage your lordship's doubts and to have a mass of this imagined influx of non-citizens marauding over India and invading India, which of course is a figment of imagination, but let's assume there are many of them. The many of them have to come one by one under this. So I will file against her, she will contest it and some third party will decide it. I will file against him, he will contest it and some third party will decide it. You have a provision, Rule 7. Form 7. Is it not going beyond 327 to supplant this by a massification exercise? That's the third point. This massification en masse is a very important point. That was a power never envisaged to the Election Commission, which is now trying to locate it in 324. Which is why I cited Joseph's case and this Jose case and this 327. Because if you assume to yourself an en masse power, then Malas, you can actually, if you had the wherewithal and the lever, you could do the entire All India at one time. All India SIR would happen. So how many, in All India population of, let's say, voting population of 90 crores, there will be 90 crore form 7 objections filed and contested. Well, this is serious. This is a lack of jurisdiction I'm arguing. Your lordship's curing and plugging a hole here and there will not matter. This is a lack of jurisdiction. You have illusions of grandeur, Mr. Election Commissioner.
Going by your argument, Dr. Singhvi,
Yes.
the commission will have never a power of SIR.
Power of?
Power of conducting the special intensive survey.
No, Malas. I'm coming to that. No, I will not go that far. You will have a power of doing a revision of rolls, which is not presumptively saying that you are at the moment assumed not to be on the roll, you show you're on the roll. And secondly, for the whole country as a whole or whole state as a whole.
It's not a routine or ordinary updating of the electoral roll.
Yes.
It's a special survey, right? Unless the rule or the statute itself contemplates a procedure to be followed, any process which should be fair enough and transparent, that can be adopted by commission.
It can't be.
Because if there is no power of survey matter ends,
no, there is no power.
Then rules will not create that power.
I must answer my lords frontally. The problem is this case has gone on for 6 months and your lordship has done a lot of effort and work to try and plug a healing touch, Malas. It's genuine.
Yes, sir.
But in that we have forgotten the law. That's why I'm saying, Malas. Assume your lordship gives all the healing touches. If there is no power, there is no power. Now my lord put a question to me. You can't say there is no power of SIR. I am saying there is no power of SIR of this kind. I'm saying so. Make it good in 2 minutes first. An SIR is a revision of rolls on an individuated or a bilateral or a small group method. And it is limited to a constituency or a part of the constituency. There is no power of en masse. That's why I start with 324. Much more important is 327. Well, 327 recognized that Parliament decides the limits to which you will go. Parliament decided the limit. It said, just now turn to Rule 21, bracket 3. Now you can read it to mean the whole of India is a constituency. That will be distorting of the whole provision. The whole of India is 565 constituencies, therefore it is also one constituency.
21 of?
Section of the Act.
Yes, preparation and
ROPA, which is the Act under 327. So, my lordship will read the connectivity. 324 read with 327. 327, the judgment of Jose. And under 327, the operative law is this one, ROPA. That's the 327 law, which the Constitution envisaged. Not Parliament alone, simpliciter.
Very opening line of 21.
Yes, let's read one.
The
electoral roll for each constituency shall be prepared.
Not of a constituency.
No. This is the preparation of the roll in the beginning. This is the original preparation of the law.
Yes.
We have passed 75 years of Indian democracy with those rolls existing.
For any constituency.
The electoral roll for each will be prepared by reference and shall come upon final. Now, may I read first what is my focus on 21.3? That's a non-obstant. It's a non-obstant. Notwithstanding anything contained in 2, the Election Commission may at any time, for reasons to be recorded, this is where your lordship's word comes, but this is the only place it comes, virtually, maybe there's one more place for this. Direct a special revision of the electoral roll for any constituency or part of a constituency in such manner as it may be fit. Well, this can't be read to distort it to mean that any constituency or part means the whole of the 535 constituencies of Parliament or the whole of the 1,000 assembly.
If the regions to be recorded are common to the all constituency of a state, can the commission still say that by virtue of this language of any constituency or part thereof, I will do only in part? Will it not be discriminatory?
No,
and will it not attribute an action of pick and choose on the part of the commission?
Let us answer the question contextually. I don't want to give a general answer. 2 facts are peculiar to this case. 2 facts. And does the law apply to those 2 facts is my question to myself.
One argument can be,
one,
that there is no region at all recorded. 2, the region recorded is non-existent. and therefore the very foundation of the power is not there.
Well, my part.
And it will apply pan state.
No, my problem is those arguments may be there. They are the how arguments. I'm on the if argument, Balus. And I'm not prepared to give up the if argument. Because if your lordship finds them not to have jurisdiction on the if argument, how will never be reached? Of course, it is important that if you have the power, how you exercise it has to have all those criteria which my Lord the Chief Justice is saying. But you don't have the if. Why don't you have the if? Let me answer that. There are two peculiarities in this whole exercise. Radical peculiarities. One, it is always minimum state-wise. And the states we've started off are the most populous states of India. Bihar and now West Bengal. There are hardly more populous states except Uttar Pradesh, Maharashtra and a few others. Two, there is no individuation of any kind, any constituency or part of a constituency. Not an attempt. Unique case. What my Lord is thinking is, well, they are trying to fit a square peg into a round hole. This was the where it was to be. They are fitting something totally different into this. Third peculiarity. Third peculiarity is that you do not follow the form made under this 21, which is form 7 inter alia, to have an individual. I can understand you have 1,000 individual exercise. Let us assume that in a constituency, you have 1,000 objections. You don't follow that. Form 7 is not followed. And fourth, this is the fourth thing. This is four peculiarities, not two. Fourth peculiarity. This is accompanied by a virtually clear declaration that the purpose of this SIR, which I say is no SIR at all, is to first say that we have an old list. This is the old list. All of you here, by my quirk of the pen, are presumptively declared to be here tentatively. Or, like a Trishanku, you are there at my largest, till I confirm your residence on my list. Well, let's be very blunt. Jurisdiction is decided by bluntness. These are, if any of these four are factually incorrect, your Lordship may correct me. The fourth is the declaration of the EC, maybe not in my blunt words, that all of you people in the whole of the Bihar who are on this list are there, but I have declared you presumptively as temporary. I will confirm you in 3 months. Give me 11 documents. Now there is 12 and 13. And I will confirm you. If I don't confirm you, goodbye, sorry, off this list. This cannot be the special revision remotely or distortedly contemplated in 21.3. And that's a...
So those who were in 2003, they were not required. They were already, they continued
right.
to be confirmed.
Right. So, no, but the role exists in 2025 also. Your Lordship is right. That's part of the discriminatory approach. No, that's an argument in my favor. I won't raise it separately. There is a role in 25 is common ground. 24, let's look at 24. There is a role in 24 January, which is this role. There was a role in 2003, which is this role. Now leave aside 2003. You are saying that everybody between these two roles who are on this role, 25 subsumes, because 25 role will include 2003 and whatever else has happened in between. So all that is said is this 25 role, I am declaring you presumptively to be my temporary guest. When I check on you, and I will check only by the citizenship test of those 11 documents, which itself are not in the form, which itself are not in the statutory form, which itself are not part of the section or the rules. Then, having presumptively put you like some kind of a temporary guest, I will then, of course, maybe confirm you, maybe not confirm you. Now, all that is detailing. My question to myself is, where is your power to do this? The power starts with 324, which was the only power they relied upon. 324 is trumped. That's a dangerous word to use nowadays. It's trumped by the law made by Parliament under 327. The law made by Parliament under 327 specifies in 21.3, in 4, in 6 and in 7 how far you can go. It nowhere contemplates this presumptive approach that pick up the role here. And till such time as you prove. So, but that's the long and short of the if question.
But then going by this argument, we have to accept that constitutional power can be limited or restricted by through legislative means.
Where the Constitution itself permits it. That's why they put 327. My lord is right. But for 327, that would not occur. That's precisely why 327 is enacted, and that's the meaning of this para 25 of this judgment. Now turn to para 25 again of the judgment. Para 25 actually puts it very pithily. Justice Fazal Ali Malik says, no, it is a judgment. No, this same judgment. Jose. Same thing here. Whereas your lordship is absolutely right. The whole purpose of enacting 327 was to allow Parliament to occupy the field which will do the nitty-gritty of electoral law.
That's part 320. Dr. Singhvi, let's not argue something which ultimately damages the very constitutionalism. 327 is a power, is an enabling power how to give effect to the constitutional scheme. Today, if you 327 you give such a vast power, then you are also probably arguing something against the basic structure doctrine.
No. 327 is not a power to overturn the Constitution. This is answered by a lordship.
327, if 327 lawmaking power can curtail or restrict or define the contours of 324.
No. No, this is exactly what is answered. Just give me 2 minutes. May I answer? This is a very important question. Your lordship's query is first answered by para 25 of the judgment. Then I'll come to the other paras. Just turn 20. No. First 25. Come to 25 first. Then I'll come to the other paras. Directly answer. Whereas Parliament is also custodian of our rights, not the Election Commission. If at all, Parliament is higher than the Election Commission.
That's right. But
Parliament chose to go so far and no further. Who are you to go further?
Let us see.
They may be wrong, Malas. They are Parliament. Now kindly come to 25. Kindly come to 25. To sum up, therefore, the legal and constitutional position is as follows. May I read this story? It's very important, Malas. Page 55 of this written submission. Yeah, please do. गर्म पानी का बोलो और बोलना कि 4 दिन के बाद में आ जाऊंगा तो जाते 4 बजे
There is only one instance of one constituency in UP where this kind of special intensive revision was done. That was done in 2001. Only one, that was Thakur Dwara, where the old.
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।